Hello, hello. Good evening, everybody. Trust you are all well. Slightly, not slight, it's a bit of a delay, has a bit of a technical issue at my end, so I do apologize about that. If you're watching this now, you should be on either my YouTube channel, welcome, or my Facebook, one of my Facebook group of pages. And tonight, I wanted to share a really exciting principle, actually, which I love to teach, especially in this day and age, in this time that we're in. I think it's absolutely pertinent that we understand this particular topic. It's under the Doctrine of Notice. So, what I'm going to do tonight, I'm going to share just the principle of what it stands and teach a bit around it as to why it's important, um, how it can be possibly applied, and give you topics to think about in terms of where you may need to understand why things are happening, how things can happen, what gives people rights to do anything to you legally, lawfully, etc. It is on the principle that you have been noticed. Now, I'm not going to probably go. I'd like to get as detailed as possible, but it'd be very difficult without providing foundational or background teaching, and that's going to be outside the scope of this training. But I'll keep it as simple as possible that anyone, whether you've got some understanding of trust or not, or equity or not, can tag along and learn. That's our purpose of this. Okay. So yeah. So if you're obviously if you are on a live and you're able to comment, if you're on Facebook and you're not in a group, or sorry, if you are in a group watching this on Facebook, you're going to have to allow permission from the software I'm using, which should be on your stream somewhere, to allow comments to be seen. If you're on YouTube, you should be able to comment, and I'm hopefully able to see it. Let me just double check my side here. Brilliant. So, yep. So we've got Jeremy, fantastic. Anything that says Facebook user, you're going to have to give permission to Facebook so that I can see who's the one giving the comment. But otherwise, thank you for your comments. I do appreciate it. All right. Now, where are we? So, also, if you're on YouTube, feel free to like the video, like the page, so you can keep abreast of anything else that's coming up that I do any training for. There is an upcoming a challenge coming up very, very soon, which I want to call the Own Nothing, Control Everything challenge, which is going to be a 3-day challenge. I'll explain more about that in the next day or so. Also, so keep a post or keep abreast of that. And yeah, and I've got information below in terms of if you want to get more information around this topic area, whether it's trust, asset protection, then you can check that out as well. So let's get involved. Let's get on with it. All right. So, right. So the Doctrine of Notice. Now, I'm going to read out of a book. If you don't have it, it's this one, Equity and Trust, 6th edition, by a gentleman called Alistair Hudson. Don't feel you have to go out and order it on Facebook. You don't need the exact edition. I've got the 6th edition, but it's just for your own personal use if you want to do your own research. I don't make up anything. All right. Everything I teach is straight out of a book, so you can verify it for yourself. Okay. I don't believe in just semantics or teaching from head knowledge, and you can't back it up anywhere. That's not going to help you any way, shape, or form. All right. You need to be able to refer to the knowledge yourself. If you have to use it for yourself, then you can see it in black and white, and no one can argue with you. Saying that what Richard said or my mate said on Facebook is not going to help you out of a problem. But when you can refer to a book from an eminent professor, from any case law, common law, then people are not able to argue with you, and more than likely you'll be able to win your argument or your case and get from A to B or live your life. That's the whole point of applying this education. And it's the reason why I teach it. It's to enable you to live your life. As I say, learn the rules of the game and then play it and play that game to win. All right. So, Doctrine of Notice. Okay. Now, it says here the Doctrine of Notice has been something of a resurgence in recent years after it had been consigned to the footnotes of many land law courses. The reason for this resurgence was a series of decisions of the House of Lords in which Lord Brown Wilkinson placed the doctrine of notice, and I repeat, at the heart of equity. In fact, let me get my scribe up so that you can, for those who have more visual learners as well as auditory learners, I'm going to be writing some notes down so you can get that for the replay. So just give me 2 seconds. Apologies for this. And then you shall be able to see my screen. I'll just get a plain white screen. I normally like to have my right, here we go. All right, I'm going to share my screen. Give me 2 seconds to do that, and that will allow you to then follow along with me for those who are visual learners. So give me 5, 4, 3, 2, 1. And away we go. You should see my screen. In fact, allow me to do one more thing. Apologies for this, but it's for your benefit. I have a very wide screen, so it'll come up really small if I leave it in the same dimension. So I'm going to just reduce it so you can see it even clearer. And then away we go. Normally this would have been done in advance, but as I said, I had some technical issues. Right. Now you should be seeing my screen a lot clearer. Just type in a Y if you can see my screen all right. It should be a blank talkboard saying Doctrine of Notice on there. Whoever asks you if this will be available to watch again, if you're in the group or watching this on YouTube, then yes. I'm here to serve you all. That is my job. So just confirm, can everyone see this screen, my screen on your page? Just type in a Y if you can do that. That'd be brilliant. And then we'll crack on. Right, so Doctrine of Notice, and it's at the heart of equity. You need to make a note of that because when I teach this to my students, I label this literally if you're going to write it inside your eyelids. Okay. So the heart of equity. Excuse my doctor's handwriting. All right. Doctrine of Notice. Right. So remember that. Okay. And this is by Lord Brown Wilkinson. Right. So it says here, Lord Brown Wilkinson placed the Doctrine of Notice at the heart of equity. So that tells you immediately when it comes to being just and being fair, then a notice is required. Okay. Now, things will start coming into plain sight the more I talk about this. This information will be applicable when I'm challenging a parking ticket. This is absolutely, I win cases based on the fact of whether I've noticed or not. If someone's knocking your door, it's on the basis of notice or not. If you get letters through your post, it's on the basis of whether you've been noticed or not. Okay. If someone's going to take you to court, or you're going to take someone else to court, or something's going to happen, it's on the basis of a notice being given, or you're putting someone on inquiry. A letter doesn't cut it. A letter is not powerful. Okay. When we talk about the pen is mightier than the sword, it's in the form of a notice. Okay. Now it could be in picture format, it could be written, but everything is via a notice. So you probably start to realize now, whenever you're driving, the reason why we've got all these signs up and down everywhere is because then you must be noticed, and therefore no one can never argue that you were not aware. Okay, so let me go into details before I get ahead of myself. But I'm going to go into details and then explain why this is absolutely imperative in everything you do to use the power of a notice. Those who going through the whole journey of understanding how things work, how law works, how the system works, etc. You get told to do something, but rarely do you get told why you need to do something. You just do it, and that's a very dangerous game to play, because when you hit a brick wall, you don't know why something's working or not working, and you don't know how to solve a problem. Okay, and then we jump from pillar to post, YouTube video to YouTube video, trying to find an answer, but not knowing why you're doing something. And if you are challenged, especially by experts in the law, if you don't know how to stand your grounds using the same rules that they're using against you, then that's where we find ourselves always at a loggerhead, or at a disposition, or a disadvantage. But once you understand what you're doing and why you're doing it, then you can stand very confident and then apply it for yourself. And this is why we need to understand this absolutely without doubt. And I'd say that the doctrine of notice is at the heart of equity. It's a foundation to pretty much everything that we do, especially in the application or enforcement of equity. All right. So let me go into more detail. Just check the notes here. Perfect. Right. So if I repeat myself, it's more for your purpose, not that I'm losing my place. Okay. That's how I teach. Right. So Doctrine of Notice has been something of a resurgence in recent years after it had been co-signed to the footnotes of many land law courses. The reason for this resurgence was a series of decisions of the House of Lords in which Lord Brown Wilkinson placed the Doctrine of Notice at the heart of equity. Okay. And that's from Barclays Bank versus O'Brien, 1994, for those who are interested. As considered already in this book, the core decision, which he's talking about here, a case called Worcesters Landesbank Gazette Trial versus Islington London Borough Council, reaffirmed the core principles on which a constructive trust will be imposed. Now, I'm not going to talk about trust in this teaching. Okay, there's different types of trust. Just for those, there's constructive trust, resulting trust, and expressed trust. Okay, just for those who are aware of that, and I'll write that down later on. But he's talking about constructive placing knowledge, and this is the part, placing knowledge of the unconscionability of the action at its center. Okay, so the case which I mentioned, which is Worcester Landesbank Gazette Trial versus London Borough Council, this Islington London Borough Council, reaffirmed the core principles on which a constructive trust, or any trust in that, for that matter, will be imposed. Okay, now this is the key part: placing knowledge of the unconscionability of the action. Okay, now when something's unconscionable, it's probably deemed to be just unnatural, immoral, not normal in the normal course of things happening. Okay, if I'm going to act unconscionable towards you, or someone acting unconscionable towards you, let's, for example, say I look you in your face, tell you got your job. By the time you get home, you get a phone call saying, sorry, you were not successful for the job, but yet still you were told the job was yours. Someone acted unconscionably towards you. You go to the shop, you buy your groceries or whatever, the corner shop, you give the guy 10 quid, he gives you back, you're expecting change of a fiver, he gives you back £1, saying no, the price has just gone up, but so there's no price announcement on there. He's acted unconscionably towards you. It can go vice versa. If you gave the guy a tenner and he gave you back £20, thinking that maybe you had a slip of the mind, or you weren't thinking straight, and you walked out the shop and not correcting him, saying, oh well, it's his loss. Yeah, that's dishonest, but you're also acting unconscionably towards him. In other words, you're not treating others how you'd want to be treated towards yourself. That's an unconscionable action. Okay, and so if you're being conscionable towards someone else, you are literally treating others how you would want to be treated, rightly or wrongly. Okay, if you're going to do someone harm and you give them notice, not that I'm a violent person, but you tell them in advance that you're not happy with it, at least you're being conscionable towards them, and they know that you're not happy about something. Okay, so just type in the Y if you understand my premise on that about being conscionable. okay, and unconscionable. Okay, it's absolutely foundational to equity, okay, and foundational to, if you want to understand trust. It's that conscionable behavior towards our fellow brothers and sisters. How are we acting? Now, in ignorance, if you are ignorant of your rights, if you are ignorant of your power, then how will you ever challenge if something is unconscionable towards you? You can complain, but it will fall on deaf ears if you don't understand what's going on. All right. So let me continue. All right. So in fact, I'm going to write this down. I'm going to repeat one more time because this is absolutely paramount. It says, placing knowledge of the unconscionability of the action at its center. Okay. So the key point here, number one, as far as the notice is concerned, and we're going to get to that, is placing knowledge. What does it say? Of the unconscionability conscionability of the action. Placing knowledge of the unconscionability of the action. Okay. Have you ever asked yourself the question, what gives another person a right to do anything? If we're all made equal, okay, under God. Now, obviously, I'm not religious, but I believe in the Creator. And you can believe in whatever you want to believe in, but ultimately, we are all the same. Okay, we come from the same place. We all act in the same way. I don't care what color your skin is. I don't care what hair color you have, or your eye color. I don't really care. We all bleed the same. We all have a mind. We all have power. Okay, we are all made in equal in someone else's image equally. All right. So the point is, if we are all equal under God, what gives me more power than you? What makes me any better than you? What gives someone the power to arrest you, overpower you, take things away from you without quote unquote your consent? How is that possible? Yeah. How is that possible? Well, if you don't understand the doctrine of notice, then we're always going to get taken advantage of, period. All right. So if everyone is equal, if you understand that paradigm, what makes anyone better than anybody else? What gives the right of one over over another? So here comes this word of unconscionability now, which is a big deal. All right. So just bear that in mind as I continue with this. So reaffirm the core principles on which the constructive trust will be imposed, placing knowledge of the unconscionability of the action at its center, as considered in the case to the core principles. So, as considered in chapter 12, which you can read in your own time. Now, this approach has demonstrated a theme in the case law of retreating to the core principles on which equitable institutions work. Now, as part of this notion of conscience, Lord Brown Wilkinson also turned to the importance of the role of the doctrine of notice in his leading speech in Barclays Bank versus O'Brien, which you can read that in your own time. Okay, a case concerning the rights of co-owners to set aside mortgages, which this book will examine later, but it's under kind of a different premise. Now, in that decision, Lord Brown Wilkinson asserted that the doctrine of notice is at the heart of equity. In that notice of, or in terms of constructive trust, knowledge of, okay, or any trust, in my opinion, of another's rights will preclude a defendant from seeking to defeat that person's right. Now, I'm going to repeat that because you might miss it if you don't understand what I'm talking about. So Lord Brown Wilkinson asserted that the doctrine of notice is at the heart of equity, which we've already established. In that notice of another's rights will preclude a defendant, okay, from seeking, preclude, in other words, will stop automatically or put them in a position beforehand, okay, from defeating someone else's rights. Okay. Now, it says in notice of, or in terms of constructive trust, knowledge of. Now, as far as I'm concerned, it's knowledge of, period. Okay. If you have notice of something, you have knowledge of something. Okay. Of another's rights will preclude the defendant from seeking to defeat that person's rights. And I'm going to continue reading. The role of the doctrine of notice in most land law courses is limited to the issue of protecting equitable interest in unregistered land as centered on a number of cases on the rights of persons in actual occupation. The purpose of this doctrine is to make persons bound by the rights of others, make persons bound by the rights of others in circumstances in which they have notice of those same rights. So the same thing as what you said here in terms of to preclude. Where is it gone now? The doctrine of notice at the heart of equity in that notice of another's rights will preclude a defendant or any person from seeking to defeat that person's rights. So if you have been put on notice about something, and we're going to go into it in more detail, automatically that will position you to be aware of someone else's rights to that situation or scenario. Okay, and ultimately have everything is a constructive trust in this public world that we live in. I ain't got time to break that down. So in essence, you are given either the gateway to knowledge or a key to find out about, because you've obviously heard the term ignorance of the law is no excuse. But you always notice that they will always say you have the right to seek a solicitor or a lawyer. They've put you on notice. Okay, so in other words, something's going to happen towards you, and unless you find out, yeah, you don't have the excuse of I didn't know. In other words, you can't use this to defeat another. Okay, or in other words, you can't, because put you on inquiry or put you on notice. It precludes you from saying I didn't know. It stops you from saying I have no idea. You can't use the term I was ignorant because they noticed you. In other words, you have to be aware that there's some information that you need to go and find out about. Now, they don't teach you this at school. Now, my point is this: if they're doing this to you, surely you should know how to utilize this for yourself in your normal affairs moving forward. Okay, so let me continue reading and repeat it one more time. The role of the doctrine of notice in most land law courses is limited to the issue of protecting equitable interests in unregistered land as centered on a number of cases on the rights of persons in actual occupation. The purpose of the doctrine is to make persons bound by the rights of others in circumstances in which they have notice of those same rights. So if someone is aware or in other words, if you put someone on notice of whatever rights they may have, they are now bound to it. Okay? Very important. So that's why you should never ignore notices being sent to you. But most people do. They didn't realize that there's a difference between a notice and a letter. So persons bound by the rights of others in circumstances in which they have notice of those same rights. It is important to note that this doctrine refers to notice of those rights. Okay. Is not the same as knowledge of those rights. In other words, it's not your responsibility when you put someone on notice to tell them exactly what it is they need to know. They just need to know that they've got to find out something. They just need to know that they need to be aware of something. It's not your job to let them know what that something is. So I'll read it out in their verbiage so you're aware of it. Persons bound by the rights of others in circumstances in which they have notice of those same rights. It is important to note that this doctrine refers to notice of those rights rather than knowledge of them. It is not required in all cases that the defendant, okay, actually know of the rights in question. Instead, it is sufficient if there has been some series of events by which the defendant is deemed to have had those rights brought sufficiently to her attention, such that she ought to be bound by them. Now, I'm going to ask the question: has anyone heard of this free letter process or the private lien process or anything like that? Just type away. Has anyone heard of that? The free letter process or the private administration process? Anyone heard of that before? Where you write notice one and you write notice to agent is notice to principal, notice to principal's notice to agent. Anyone ever heard of that before? Okay. Now, whilst I'm waiting for comments to come in, but that's exactly what we're doing here. You're giving people sufficient notice, enough that they cannot deny that they were aware that something was going on. All right. Or if I use the words as the esteemed author has in this particular book, it is not required in all cases that the defendant actually know the rights of the in question. It's instead, it is sufficient if there has been some series of events. You send notice one, notice two, notice three, etc. Okay, a series of events by which the defendant is deemed to have had those rights brought sufficiently to her attention. So you're giving them notice of something and you're putting it in their attention. Okay, you've given them attention, or the term used, you put them on inquiry. All right. And it also says specifically brought to her attention such that she ought to be bound by them. Okay, now it says here the ambit of the doctrine of notice is set out most clearly in the case Hunt versus Luck, which I wanted to read out for you today, but I don't have it available, so you have to do the research yourself on that one. But what I want to talk about, there are three strands to the doctrine of notice. There's something called actual notice, something called imputed notice, and then something called constructive notice, which I will go through shortly. Okay. Okay, so I hear what you're saying, Louise. In terms of exercising your right to private life, now there is more to it than just saying something like that. Okay, obviously this is just bringing into your attention that things like that should be put into a form of notice. You also have to back it up with something. Okay, I'm sure you probably have, but just in case you haven't, which again that's kind of outside the context of this training. But I see what you're saying. But 9 times out of 10, you need to, well, not 9, 10 times out of 10, everything you do, if you're going to put someone else on inquiry, another authority, another company, another individual, whoever it might be, if you're you need to put it in the form of a notice. Okay, parents, especially with vaccinations, you can contact the school and give them, tell them what you want and don't want, what you agree to, what you don't agree to. Put it in the form of a notice. Now, I'm going to tell you this now, probably 9 times out of 10, 9 out of 10 people have no idea why notice. Even lawyers have no idea why notice is important. Yes, most lawyers have no idea. But decent judges do. Okay? Even in house repossessions, you have to be noticed so they can't take you home. Right? Formalities need to be followed. There's a reason. And the law, okay, is the procedure of law or the statutory instruments are set up. Whoever writes these instruments understands these implicitly. Okay, so most people will follow it to the letter, but don't know why they're following it. I'm showing you why it's important. And so then you can challenge certain things. Now you know this, you can challenge certain things because you say, well, I wasn't noticed of this. So therefore, no matter how parking tickets I've won that are contested, just on the basis that, well, I wasn't sufficiently noticed. So, if, for example, no one can film me without your authority. Now, if you put someone on notice and you don't rebut the notice, then you have given someone your authority. This telephone call may be recorded. That's giving you a notice. So if you fail to say I don't agree to it, then you agree to it. Okay, I use this against bailiffs. I use this pretty much in any kind of commercial um, interaction that I need to in get involved with. If I ever get involved with anybody, then it'll be in the form of a notice. If I'm preparing for court, it'll be three-letter process, whatever. It's on the basis of understanding that I've noticed you of your rights. You need to go and find out what they are. I'm not going to tell you what they are. Yeah, anyone who's in the process of buying houses or need planning permission, it's a case in point. You have to give a notice for your neighbours, okay, for planning, so they can have the right to contest. And once that period has passed, they've got to shut up if they disagree, because they had the opportunity to say something. Now, they're not going to tell you exactly what the rights are in that notice, but they say go and check it out on this website, and then you can do your research to find out what those rights are. And I'm you're gonna have to take my word for it for now. Okay, my students will know, my stories and everything else, but this is absolutely watertight. And obviously, I'm reading it out of a law book. I'm not, and there's case laws. I already mentioned 3 already that talk about the power of the doctrine of notice and why it is absolutely imperative you understand this. If there's any questions, please. You don't need an official notice. You just write notice, and that's it. Okay, there's no official. Remember, once you understand your power, you got to start exercising it. The challenge is that everyone likes to keep us ignorant, or so we're not aware of our rights. Even lawyers will give you poor advice because they have no idea what they're talking about as well. Only a handful actually know what they're talking about. So if you want to write a notice, you just stick notice on top and say, I'm formally noticing you of. Take notes of. Okay, there's no official form required. You are the form. You are the one with the authority to give notice, and that's what gives people the rights over another. Because I need your permission. I can't walk into your home without permission. I can't take your car without permission. I can't do anything without your permission. Okay, so in order to get your permission from you, I can ask you directly, yeah, or I can put you give you a form of a notice, which we don't know why a notice is used. Now, if you're ignorant of why a notice is used and you keep silent to it, then I've just alternatively found another way to get your authority to do something, and we'll use it against you if necessary because you didn't stop me. So there should be a lot of ahas going on in your minds now, situations maybe in the past of why certain things have happened. All right. So, right. So let me talk about these 3 different types of notice, and then we're going to wrap it up for now. But it says here, the defendant will be said to have notice of a claimant's rights in these 3 situations. Now, the first is what we call actual notice, and that refers to the situation in which the rights have been brought directly to the attention of the defendant. The defendant is just someone who you're speaking to. Okay, you always see yourself as a claimant. So whoever is you're dealing with will be ultimately the defendant. That's how they utilize it in this book. Okay, don't see it any other way. So the first is called an actual notice. Let me write this down for you. Okay, so there's 3 types of notices that can be used, and the first one is called actual. Let me write it a bit clearer for those. Actual notice. Okay. And basically, what that is, it refers to a situation in which the rights have been brought directly to the attention of the other. Right. Directly to the attention of the defendant. such that she does know of the existence and nature of those rights. So they are aware of the existence and nature, right, of those rights. Okay, that's actual notice. The second one is what we call imputed notice. And imputed notice is a strand which arises most often in case law. Imputed notice arises when some person has notice of the claimant's rights in circumstances in which the defendant ought to be bound by the notice of that third person. So I repeat, imputed notice arises when some person has notice of the claimant's rights in circumstances in which the defendant ought to be bound by the notice of that third person. So, for example, the third person may be the defendant's agent, okay, as in the case here called Kingsnorth Finance versus Tizard. In this case, Tizard, the finance company, employed a surveyor, okay? So therefore, the finance company's agent, all right? The finance company employed a surveyor, so that was the finance company's agent, all right? Then it says, excuse me, to inspect the property before entering into a mortgage agreement with the legal owner of that property. It was held that the surveyor had notice of the rights of the legal owner's wife due to his failure to inspect the property sufficiently closely, and because of the finance company's failure to spot discrepancies in the information provided to it by the legal owner, which was the wife, yeah, the court held that because the agent or surveyor had notice of these rights, the principal, the finance company, ought similarly to have constructive notice of everything of which the legal agent had notice of, i.e., notice to agent is notice to principal, notice to principal is notice to agent. Imputed notice. Okay. There's nothing to cover yourself without prejudice. You need it to be aware. You need people to be aware. There's no without prejudice. You don't want it to be withheld. You want people to know that you're writing a notice. Okay, whoever wrote that, sorry, I don't have your name. You don't need to use the words without prejudice. You don't need anything withheld in this instance. The whole point of it is that you want someone to be aware. You want it to be used as evidence, if required, that you put someone on notice. So you don't want it without prejudice in this instance. Yeah. All right. So the third one is constructive notice. All right, Kevin Mark, how you doing? Right. Constructive notice arises when a person knows of certain facts which put him on inquiry. When a person knows of certain facts right? They're aware of certain facts which put him on inquiry. It's a very powerful term, on inquiry. So, for example, I put a notice that I'm having this Facebook Live today. That was a form of a notice, and I put you on inquiry to turn up today because you are aware the time and the location of how to attend. So you're aware of certain facts. So I've put you on inquiry, okay, via a notice that the Facebook Live training is taking place today. Now that doesn't make it constructive notice; it's a notice, okay. And I've put you on inquiry. That's the point I'm trying to make. Very, very powerful, right? Little terms like that, very powerful. I've put you on inquiry. When you're, if you want to add more vocabulary to your arsenal, if you're dealing with certain individuals or entities, that term "put you on inquiry" is very, very powerful. All right, let me continue reading. So, third category, constructive notice arises when the person knows of certain rights which put him on inquiry as to the possible existence of the rights of another person. Okay, and that person fails to make such inquiry or take such other steps as are response as are reasonable in the circumstances. So these are normally for people who act in a fiduciary capacity, okay, or act, or some kind of a quote unquote contract is put in place, and they've failed to do their job. All right, so I'm going to continue reading. Failure to make such inquiries will lead to finding that such a person has a constructive notice of the other person's rights and therefore takes subject to it. So constructive notice operates to bring within its ambit situations in which the defendant does not have actual notice, but is deemed to have notice, potentially through the failure of another person to identify reasonably ascertainable information. All right. So that would apply to lawyers, anyone operating in a professional capacity for you or on behalf of you. Normally, you'd say that they'll you can construe that they had notice to do something but failed to do it. Either they failed to let someone else know, or they failed to petition someone to do something. That's where you construe. That's where you can say you construe. Okay, I'm not going to go into it in too much detail, but the legal word of construe, okay, comes from the word construct. Okay, if you got a Black's Law dictionary, look it up. All right, what it means to construct. Okay, it's not your English word. Okay, so the verb construe at law comes from the verb construct. All right, so that's all I'm going to say about that for this lesson now. But just so you know that there are three types of notice that can be all used at the same time in different capacity. You'll mainly tend to use actual and imputed notice most of the time. The main part I'm trying to really highlight for you is that a notice, number one, is to make others be aware that they have rights, okay, pertaining to whatever information you're sharing with them, and you do not have to be the one to tell them what those rights are, especially with something that is which is generally ascertainable or accepted. They need to go and find a law for themselves. All right. So you can apply this, as I said, in absolutely pretty much any capacity where you're dealing with an outside entity, whether it's a school, some political body, professional body, whether you do business with others in their professional capacity. A notice can be used, and they are very, very, very powerful, especially if you're dealing with someone who has no idea what a notice even is. All right, they need to go and do their own research. And I had I did a bailiff course last year, end of 2019, and the Doctrine of Notice is a very powerful part of that course, in terms of how to keep third parties, bailiffs, whoever, even the police, if they're not have no business being anywhere near you. Okay, and I'm sorry if it sounds very negative when I talk about bailiffs and police. Just that I've helped so many people in these negative situations, so that's the stories that I have. But ultimately, you can utilize this in business, whatever, to protect yourself. The point I'm trying to make is, with the power of a notice, if it's not adhered to, we'll throw a case out. Okay, the law will be on your side, equity will be on your side, because you have done your part to put others on inquiry, to let people know that they have rights or they have information they need to be aware of. They need to go and do their research. It's not for you to tell, it's not for you to do their job for them, but you're telling them, which is a conscionable act, an equitable position to be in. Because he who seeks equity must do equity. You're by using a notice, you're putting someone else on a position that they need to go and find out some further information, and you're doing your part. That's a good thing to do. In other words, all right. Any questions? Any questions on this? Yeah. If you're enjoying it, please, if you're especially on Facebook, any hearts or thumbs up would be really appreciated. So others can get a hold of this. If you're going to watch this on the replay, then feel free to, again, to post questions afterwards if you wish. Just so much in a few minutes. Thank you ever so much. No, much appreciated. I've done a couple of law workshops, and you just talking more. No, that's my pleasure, Louise. Not a problem at all. Okay, I'm here to serve. This is my gift to mankind, and I'm going to share my gift. That's it. I'm here to serve you all, and that's what I'm doing. And each and every one of us have a gift that we can be doing, helping others as well, in whatever capacity that may be in. All right. That's right. It looks at your conscience first and foremost. That is priority, and there's things that we're going to go into. And I will be announcing this week about the 3-day Own Nothing, Control Everything challenge. So just keep your eyes peeled and posted. I'll give you more information about that, and I'm going to basically teach you about how trusts work in that 3 days challenge. Really excited about that. And my aim really in this group is just to keep the knowledge as much as possible true and pure, and allow you to to learn as much as you possibly can within the group and share. All right. So look, I don't want to take up too much more time, much more time on a Sunday evening. I've either got school shirts to iron, or things to prepare, dinner to eat, whatever. So enjoy. Thank you for your time. I do appreciate it. Thank you for spending your time with me. It's not something you can get back, so I do. I'm honoured for that. Thank you so much. Watch the replay. Share this with your friends if you feel people need to know about this. Otherwise, have a good evening. Catch you guys all real soon. Thank you very much. Cheers.